Great to see well over 100 participants today for this webinar. My name is Matt Wagoner. I'm the Information Specialist Statewide Lead. As part of organizational efficiency, the information specialists have consolidated and taken in-house processing of the guardianship packets. And we're doing that now on a centralized basis instead of a regional office by regional office basis. Just a reminder that all questions and requests for support are funneled through our email address, and I'm sure we'll cover that during our during the course of the webinar. I wanted to give a quick statement about what you can expect when working with the information specialists / guardianship coordinators, and what we will be able to support you with, and maybe what we won't be able to support you with. Overall, our function in the process of requesting the Office of General Counsel file the petition for guardianship is to provide technical assistance for the overall completion of the packet. We are able to support you in how the questions should be answered, the format that the packet should be presented. Specific information that Office of General Counsel will request when reviewing to determine if they will file the petition for guardianship. But our main purpose is only to provide technical assistance when it comes to the packet itself. We're unable to provide the team with perhaps information regarding what might be in the best interest of the individual, locating different options or resources. We're not able to provide anything that would appear to be legal advice, and we'll probably err on the side of caution and encourage teams to reach out to legal counsel on their own, either through legal aid or other resources. But just so that we can clear up any confusion, our primary purpose in this process is to review the packet and to provide technical assistance concerning the packet. And that really is the purpose of today's webinar, is to go through the packet page by page and to let you know exactly what's expected and needed for us to be able to successfully submit that to the Office of General Counsel. So from there, I'm going to turn it over to Stacy and Darcy, who are veteran guardianship coordinators. They were guardianship coordinators prior to the information specialists absorbing that responsibility. They are extremely knowledgeable and outstanding to work with. So Stacy and Darcy, I'm going to give it to you. And Stacy, I'm going to confirm you're driving the slide deck. Is that correct?
It looks like on the screen that you are.
Okay, I'm driving. Okay, so I'm going to mute and turn it over to you, Stacy.
All right. Good morning, everybody. I'm Stacy Bond, and I'm an information specialist, and I am located in Springfield, Missouri. And Matt, if you'll go to slide 2. This is just things that you should know. When you get a blank guardianship packet right now, it starts out at 32 pages, just so you're aware of the size of this. We will not be going over every single question on every page on a packet. That would be a really long PowerPoint. So we'll just be giving an overview pretty much of each section and highlighting some of the things that we have found are frequently asked questions or common mistakes that are made when filling out the guardianship packet. You may not be able to read each page that is on the screen as they come up, and that's okay. We are just giving an overview, and we're not going to be going line by line. And on this page here, just reminding that packets need to be thoroughly completed and that they should be typed. The only exception to this is the Physicians Interrogatories, and that's just because a lot of times physicians are too busy to sit down and type them out, so we get them handwritten quite often. It's just important to remember that if they are handwritten, they should be legible. Guardianship packets do become exhibits attached to the petition for guardianship that are filed with the court. So that's a good thing to remember when you're filling this out, that this is going to end up being a court document. Always consider alternatives and be prepared to explain why those alternatives are not appropriate before you pursue full guardianship. Guardianship packets were last revised in April of 2021. Ask that you make sure that you're using the latest version. Some of you may have older versions saved on your computers. Just ask that you get rid of those and make sure you have the current version, because if you hand in an older version, we will ask you to convert it to the newer one from April of 2021. And then just a reminder for you all that support coordinators do attend the guardianship hearing and testify in court. Now we can go to page 3.
Hello, I'm Darcy Armstrong, and I'm with the Central Missouri Regional Office. And so where do I submit a guardianship request? As of December 1st of last year, all the requests are sent to ddguardianship@dmh.mo.gov. The requests will go to this email and then be assigned to an information specialist. And the specialist will handle the guardianship completion and work with the support coordinator on technical assistance. Next.
All right, on this slide, this is the very first page of the guardianship packet whenever you get it. And I will say that as of my last check, the first page is not consistent with the changes that have recently happened for the submission of the packet. So I've kind of taken that, a little part of that out, and typed in where you can kind of see it's messed up a little bit in there. I typed in where the packets go to now. But whenever you get a packet, it may say something else there, but we're trying to get that fixed so that everything matches. But this is just some tips that you need to go through and read prior to filling out the packet. Will help you as you go along through the packet. And important to note that when you're completing a packet, you just make sure that the answer that you're giving matches the question that you're responding to. Read the question and focus your response to that question, specifically on that question. So occasionally responses that we get to questions don't match the questions, so they have to be redone. And next slide.
Pages 2 and 3 of the packet consists of the checklist, and the only exception as far as designation of resident, which is number 10, that's only required if the proposed guardian lives out of state, or if they don't, you can just put NA. And all of the items on the checklist are required. Next.
Okay, and in the packet, the next 4 pages of the packet will be the physician's interrogatories. And we're going to take a look at each of the pages of the physician's interrogatories and make some notes about specific questions on there, just things that we need to look for when we receive the interrogatories. And the next slide.
You have to make sure that the professional filling out the interrogatories is a qualified physician, psychologist, or psychiatrist. It cannot be signed by a physician's assistant or a nurse practitioner. However, they can be completed by a nurse practitioner or an assistant, but they must be signed by the physician. And as long as it's accepted by the physician, they review it and make sure that everything is correct, and then they can sign off on it. And the interrogatories must be notarized, and they should be no more than 6 months old when the hearing is held, prior to the hearing. And if the date on the form is nearing 6 months before the packet is submitted, then please have the physician fill out and sign the affidavit of no change that has been recently notarized. Next slide.
Next slide. Just a quick note on the affidavit of no change. That is something that if you run into needing one, you just ask us for one and we have them. And this next slide is the second page of the Physicians Interrogatories. And just make sure that all the questions on here have been answered and that you're able to clearly read them. Pointing out that number 10, the question is, do you consider so-and-so to be incapacitated, and that is unable by reason of any physical or mental cognitive condition, that they lack the capacity to manage their own requirements of food, clothing, shelter, safety, medical care, and such. You need to make sure that this question says yes, because this is basically where they're giving their recommendation that this person needs a guardian. Next slide.
Number 12 of the Physician Interrogatories, you need to make sure that it says yes for conservator, and that is provided by the physician's recommendation. And as well as number 14, the answer must be consistent as far as the least restrictive environment. If the physician recommends a natural home versus the SC recommending a residential placement, the team needs to come together and make that final decision and consult with the physician because they have to be consistent. Next slide.
All right, this is the last page of the Physicians Interrogatories. And just you need to note that numbers 15 and 16. Do you believe it would be in their best interest to appoint a guardian? Do you consider it would be in their best interest to appoint a conservator? So obviously either one or both of these should say yes, depending on what's being applied for. Make sure that the physician has signed it, and also make sure that it has been notarized and dated, and that the date cannot be more than 6 months old. If it is approaching 6 month mark, like if you are just now turning in your guardianship packet and let's say the physician's interrogatories are 4 or 5 months old, got to remember that it has to be gone through for any corrections, and it also has to sit for a little bit while waiting on a court date. So approaching 4 or 5 months and you haven't submitted it yet, then you probably want to go ahead and ask us for an affidavit of no change so that we can have that with it and not cause any further delays when we turn it into general counsel. Next slide.
And on pages 8 through 11 in the packet are the case manager's statement.
We're going to look at each page on the case manager's statement individually.
We can go on to the next.
As I know that this is a big one that concerns everyone. The first page of this is just general information. This is where you'll list your place of employment, your position, your educational background, your contact with the client, or also the proposed ward. Either way, you'll see that it interchanged in this presentation. And then who currently has custody of the client. And the note on here, if the support coordinator changes prior to the packet being submitted, which happens pretty often, it does not need to be redone. However, you do need to update it with the current support coordinator's information, and the cover letter should include the current information of the new support coordinator. And again, case manager statements can't be more than 6 months old either when the court hearing is held. If they're getting close to 6 months, then we would do the affidavit of no change. Next slide.
The next page of the case manager statement. Everything needs to be in detail, as much detail as possible, and answered thoroughly, because this will also assist with the SC testifying in court and make it easier for them. So if you can provide as many details as possible for most of all the questions throughout the entire case manager statement, it will be very helpful for general counsel as well as the SC. Next.
Okay. I was reading a chat. On this page, I'll read questions 16 and 17. Does this placement place the least possible restriction on the proposed ward's personal liberty? You just need to make sure that, you know, what we're recommending or where they're at is the least restrictions on this person. Give as many details as you can when you answer these questions. It says avoid brief answers and explain why. Important thing to remember is just questions and answers. So just go through it. Whatever the question's asking, answer that. Put as many details as you can in there as possible. It does help you later on as you are testifying in court. On number 18, you need to make sure you provide the full name and relationship to the proposed ward of the proposed guardian on here. Like you put Jane Doe is his mother, or, you know, public administrator in their name. County wouldn't hurt. Number 19, note any exceptions if the proposed guardian is a public administrator. So there are a few questions on here that you need to make sure you read all the way to the end, because sometimes at the end of the sentence, it'll say you don't have to do this if it's the public administrator. So just keep an eye out for that as you go through it. And next slide.
This is the final page of the case manager's statement. And case manager's signature needs to be on there, and this also needs to be notarized, and that the date signed is not nearing or past the 6-month mark, similar to the doctor's interrogatories.
And I see in chat somebody had just asked, do the SC forms need to be notarized? And yes, they do.
Yes, yes.
We won't be accepted if they are not notarized.
Next.
All right, now this is the financial statement and personal property. And this is the statement for the proposed ward and not the proposed guardian. Things on here: checking accounts, savings accounts. Do they have any stocks and bonds? Do they own any vehicles or any other type of personal property? Important, just if it's not applicable to them, or, you know, they don't have it, then just write NA or zero balance or something like that there instead of leaving it blank. That way we know that, you know, you looked at it and addressed it and it wasn't just skipped. Because if it's blank on savings accounts, then do we know, do they not have any savings accounts, or did we just not answer that? So just make sure that you either put NA or zero if it's not applicable to them on here. Next slide.
And like Stacy said, that you only include the income of the consumer and not the proposed guardian. And if there's something not applicable, write NA and do not leave it blank. And all the income needs to be thoroughly explored, and make sure that, like I said, if you don't find anything or if there is nothing, then just put NA. However, everything needs to be explored.
It is a little bit simpler because it's the individual's income and not the proposed guardian. And I'd say most of the time we're just dealing with Social Security or SSI payments. Occasionally they do have some other income that they have coming in, but I say typically it's SSI, and it makes it a little bit easier to fill out. Next slide. And this is the list of relatives. So when you fill out a guardianship packet, you are going to have to locate relatives. And you may have to conduct a due diligence search for family members. If there are any known, close, and suitable family members who are unwilling to become guardian, or then you need to have them sign a statement that indicates that they are not willing to serve and that they agree to the proposed guardian. Now, in a perfect world, you would get everybody to do that, but we live in an imperfect world, and a lot of times you either can't find them or they'll refuse to write one. If that's the case, then they just ask that you include a copy of the letter that you sent to them and send it in with the packet. That way we get an idea of what efforts were made to find them, even though they refused to cooperate or you couldn't find them. And you would just list any adult siblings or adult children or parents. Next slide.
This slide continues on with what the previous slide had said as far as siblings and address and age. However, there's something called other close relatives, and close relatives does not mean people that are in close proximity of the consumer. This means close in bloodline, aunt, uncle, grandparent, etc. You need to also make sure that you list any other adults living with the individual, non-DMH clients. And Missouri law prohibits the court from appointing an unrelated third party as a guardian or conservator unless there are no other suitable relatives that are willing to serve.
Right, so that's the why. That's why we have to find the relatives, because it is Missouri law, and we have to have a due diligence when it comes to family.
All reasonable efforts, correct. Next.
All right, this is the list of steps taken to locate relatives. Were you able to locate an address for the mother and father, addresses for brothers and sisters, adult children? But basically, this is all of the people that you either were or were not able to locate. You would put that down on here. If they do not have any children or siblings, don't leave it blank. Just put NA on there so we know that it just wasn't skipped. If you answer no to any of 1 through 5, then you need to finish number 6 and make sure that you go through the steps and initial each one of those blanks on number 6. It's where you document the due and diligent efforts that you did to look for the family members. And next slide.
This page is for information for guardians and conservators. This includes the duties that they're going to have and the obligation that they're going to have over the over the consumer being their guardian. And there are, I believe, 9 prescribed duties that the conservator, proposed guardian, needs to review with signature and the date that they review it. And they must sign it. However, if the proposed guardian is a public administrator, they do not need to sign this page. Nobody needs to sign it.
And again, that's something that you can see on the checklist at the beginning of the packet, forms in this part that can be skipped for the different scenarios, like whether or not it's a public administrator or a parent, an adult sibling, or an adult child. Many of these forms that we're getting ready to go through can be skipped in those scenarios. And then this next slide is the background screening form. And again, you don't have to include it if the proposed guardian is a public administrator or parent, adult child, adult sibling. Pretty self-explanatory on the background screening. And then if you go to the next slide.
These are just the instructions on how to complete the background screening. Like Stacy had just said, do not include if the proposed guardian is the public administrator or parent, adult child, or adult sibling. And it shows where to send the screening to in order to have processed, as well as all the instructions.
All right, next slide. This is the consent to appointment, and the proposed guardian has to list 3 people who do not live with them that will know their whereabouts on this page. Need to make sure that this one isn't skipped. Do not include if the proposed guardian is the public administrator. It's pretty self-explanatory on this. Make sure you put the last 4 digits of the Social Security number on number 6. And then we have to sign it and date it. It's just saying that they agree to appointment as guardian.
This page is only applicable if the proposed guardian lives outside of the state of Missouri. And they'll need to fill it out, the resident and the signature and the date, and send it back in to the SC in order to be submitted with the guardianship packet. However, that's just if the proposed guardian is out of state.
Right, so it's important to remember there's an extra form to fill out if they reside out of state.
Correct. Next slide.
All right, the next 3 pages of the guardianship packet will be the domicile statement, and this is just information on where the client currently resides, as well as their prior residences for up to 3 years. And we're going to take a closer look at page 25 of the packet.
Number 4 says, does the patient own any property in this county or any other county in Missouri? And this needs to be explored, and so you can put in specific answers. And if they own any other property in any other state, that needs to be explored as well, thoroughly explored. And then the date when they first entered the mental health system. And this is important. Make sure you answer it completely at the age and complete address where they were living at the time they first entered the mental health system and how long they were at this address. You cannot leave any of these blank. You cannot put NA. You need to find out all the information.
Yeah, that's a common one that is often overlooked or not answered on all of the sections.
Next slide.
And information needed for confidential filing. There's a couple of places on here where you just need to make sure that you put the whole social security number and not just the last 4. That's a mistake commonly made. We often get them with the last 4 digits on there. Have to get the whole social security number. And then note exceptions on this page for the public administrator.
On this page, statement regarding proposed guardian. Who did you consider to serve as guardian and/or conservator? You must put other people other than the current one that you are recommending. You just have to state who did you consider, who did the team consider. And then on number 6, this is very important as well. You need to state why you are not recommending family members or a certain family member, and as far as why they are considered not being guardian or conservator, even if you had considered them, why they are not being recommended. Make sure that you list all the adults, including the list of relatives that are also on the form.
Right, so basically the list of relatives and this form, the statement regarding the proposed guardian, need to match. So any adult that you listed on the list of relatives needs to be listed on this page as well. Next slide. This is just a list of the prospective witnesses, and you have the physician, the service coordinator, the proposed guardian, and then anybody else that might be on the witness list. This is just where you would put their contact information on there. Next slide.
This is the statement regarding any pending criminal charges. If there are criminal charges, then you need to put yes, and then you need to explain and complete the following on number 1 and descriptions and what the case number is. And you can probably find this under CaseNet. And if the answer is no to question 1, then you move straight to question 2 and any other background history, criminal history that the team or you are aware of, or the provider. And then that needs to be described in length if there are any other past criminal history.
All right, and that would complete the guardianship packet. So now, Matt, did you want us to go through questions in the chat?
Yeah, I think it's a good idea to kind of start going through questions in chat. We've got the time. We scheduled a lot more time than we needed just so that we could get through questions and provide some support. Some questions we'll be able to answer today. Some questions we'll have to respond in the frequently asked questions. So I'm fine if I'll go through and I'll read them out and we can answer them. Okay. First question is from Joseph. He's got a successor guardianship packet that needs to be completed pretty quickly. He has some questions about getting it filled out, and that an attorney is asking for $800 minimum to do the packet. So I hope that Joseph, it doesn't look, that was more of a statement than it is a question. So Joseph, if you have further questions, you can email the guardianship questions towards ddguardianship@dmh.mo.gov. If we haven't thoroughly answered your question, or if we've got time, you can put it in chat. The training is being recorded. PowerPoint, transcript, Q&A, all of that will be posted. Can you place guardianship packet location in the chat? So, so we can do one of two things. When you reach out, so typically when you reach out to the DD Guardianship initially, I typically respond to those questions. We have some boilerplate language that we put in an email to you and to the team to begin considering before we jump right into doing a guardianship packet about pursuing multiple other options or exploring other options such as supported decision making, durable power of attorney. Could the individual's needs be met with a rep payee, things like that. But we will also typically provide the packet to you. The packet is also out on the Office of General Counsel's webpage under forms. So it is available there. But typically, as we move forward, we'll provide you with the most up-to-date packet. It bears saying now, we've had it happen recently that a packet was submitted to us on the wrong form, and we had to return it to the team to be changed. So it is very important to ensure that the packet you have is the one dated April of 2021.
Matt, if you'd like, I can read the questions to you. I've collected them all.
Okay, yeah, that'd be great.
Okay, I think it'd be easier for you than tracking them in the chat. Okay, we have one from Monet Brown. Are there any supports available to help a person get interrogatories completed when physicians refuse to provide because the person cannot give consent?
Darcy, Stacy, have you ever run into this?
I've never run into that specifically. They've always been able to get interrogatories from a physician. However, I suppose it is something that could be court ordered.
I agree, and I also have never run into that issue.
I guess, Monet, our response is going to be that might be a question that we have to run past general counsel to get them to weigh in on. So we are not going to have a specific answer today, but it is something that we'll put on the frequently asked questions.
Okay, from Cheryl. There used to be a 2-page interrogatory. Is that still able to be used?
You need to use the interrogatories that are provided in this specific packet.
Christine, I'm sorry, go ahead.
Just as as a statement, the packet that's dated April of 2021 is the packet that has to be used. Any other iteration is considered invalid, and just plan on using the packet. It's a 32-page document. Plan on using that.
Okay, from Christine, do the SC forms need to be notarized? And yes, you've covered that.
Yep.
Marie, is it acceptable for a physician to use their own form rather than the provided interrogatories?
I would
We'll
say
just-
that
I would say no.
the quick answer to that is no. And there's a longer answer to that that is a maybe. And that would be if the form that they were using stated that they approve of the interrogatories that were filled out by the PA or the nurse practitioner, then they signed the forms, like saying they didn't have to fill out the questions on the physician's interrogatories so long as they sign off on them and say that they agree with them. However, it's a lot easier if you just have the physician fill out the provided interrogatories.
And I think just to clarify, Stacy, I think they're asking if they have their own interrogatory, the doctor has their own.
Right, and I'm
interrogatory
saying if
statement.
on that form that the doctor has, he
Mhm.
says, I approve of the interrogatories
Okay.
signed off on by, PA so-and-so.
So I think the easy question is always use the packet dated April of 2021.
Yeah.
What would be the name of the savings account if it's through the HSO?
I'm not exactly sure what that means.
I don't know.
Maybe the person that posted that could clarify that a little bit in the chat.
It's like a health
But-
savings account, I'm assuming. We just need to make
Yeah,
sure that
I'm-
if they do have a health savings account that, it's listed maybe under savings accounts.
Lisa wants to know, do you have a list of ABLE account, ABLE account?
I do not.
I do not.
Joanna? Joanna, I was always told that the proposed guardian needs to work on finding the relatives, not us. Is that not the case?
That is not the case because you don't know the dynamics of the family, and the proposed guardian would just give you any information that they want to give you. So
Need a due
we need
diligence
to
search.
we're responsible for a due diligence search.
Jamie's question is, if the individual is currently their own guardian, the team wants to pursue guardianship, and the individual currently disagrees with you contacting family or a doctor to pursue guardianship, is it a HIPAA violation if we contact others that they requested us not to contact?
I think that's a question that I would take to general counsel.
I would agree.
Mika would like to know, does the information for guardians and conservators form have to be notarized?
No, it does not.
Just the interrogatories and the case manager statement.
Statements signed by family members stating that they agree to the proposed guardian have to have statement notarized.
No, they do not. They can be even handwritten as long as it's legible. Just as long as it's something saying that they were asked and here's why they decline, and then sign and date it.
So if the public administrator is the proposed guardian, you have to go through this process now. It's a question. In the past, the PA in our county petitions for guardianship without these documents being completed.
There are different scenarios. If going through DMH, then this is the way you would do it.
Can this guardianship documentation be completed for an individual who needs limited guardianship?
Yes, this can be completed for limited guardianship.
What documentation is needed in order to contact relatives? Would a release of information have to be done for each person to be contacted? What if the consumer is not in agreement?
Second part of that question, I would probably ask General Counsel for further clarification on that. And the first part of that is if you want to draw up a letter that doesn't give a lot of specific information, but just a letter to the last known address of any family member, and then track the progress of that letter. And then that's if you can't find them or if they refuse, that's what you would include with the packet.
And what if the consumer is not in agreement?
That's the part that I would ask
General
for further
counsel.
clarification on.
Do we need to seek out biological relatives if an individual has been adopted?
I'm not
I've never
exactly
run into
sure.
that. Right, I would never run into that. I haven't. But if their rights were terminated,
Yeah.
then I would say no. I mean, technically they are biological, but they don't have any parental rights to that consumer.
Right, because
If-
adoption is the ceasing of any sort of parental rights of the biological parents.
And in reference to the domicile part of the document, what if the ward is homeless?
Well, then I think you would just note that they are homeless and probably, you know, if they're staying in a shelter or somewhere, list wherever they're staying at.
In detail.
If the client is a child aging out of children's division and the CD worker is out of one county and the child lives in another county, I'm guessing we contact the PA in the county that they live in, not the county they came from.
Yeah, it's my understanding it would be the county that their residence is in.
Do two separate documents need to be completed if the team is seeking co-guardianship?
Co-guardianship is a fun question because it was my understanding that DMH does not do co-guardianships.
Should the unclaimed property site be accessed to see if the consumer has property they may not know about? And if so, what documentation would need to be given?
I've never had that come up, but that's probably something I'd have to look a little more into for an answer to that.
Under what circumstances is this packet completed? I have had individuals and their guardians go through the guardianship process on their own, and I have not been involved.
I don't know that I understand the question.
So that's like a private guardianship with their own legal counsel. We wouldn't be involved. I mean, if they're still a consumer in our, then I would expect the team or SC to become aware or to reach out to the consumer and everyone involved in the consumer's life to try and get some information to where they're at legally.
Right. If the family is going through a private attorney, then if that's what they're doing, then we just let them do that. General counsel doesn't have anything to do with that. Only if it is going through DMH, which, you know, part of the process before you fill out a guardianship packet is to, you know, make sure the family didn't have the funds needed to get their own private attorney, or also you can try applying through legal aid, because a lot of times they'll take guardianship cases at no charge if they qualify financially. But DMH wouldn't have anything to do with any of those scenarios. DMH is supposed to be considered the option of last resort.
Do we need to refer family to legal aid before starting a packet, or do we help them whether they are going to legal aid versus our legal team?
They do need to apply through legal aid first.
Then private counsel. Make sure all options have been exhausted before going through DMH.
How do the filing fees, etc., get paid?
That is a question for general counsel, because we don't have anything to do with that.
I had a guardianship meeting at the courthouse scheduled back in December, which was within the 6 months time frame. And when we arrived at the courthouse, it was rescheduled for March 1st. Do I need to have the provider get back with the doctor to sign another statement?
I would do an affidavit of no change in that scenario. I mean, unless there's been any significant changes since then. But if everything is pretty much the same, then I would have them fill out an affidavit of no change, so it's not delayed any further when you get to court.
And you can find that on the umh.mo.gov.dd, the general counsel's site as well.
Or you can ask
Actual form, or you can ask one of the information specialists.
DD Guardianship at dmh.mo.gov.
Working with a physician that will not complete the interrogatory from the packet, but will submit information and agrees that the individual needs a guardian, but wrote this on their hospital forms. Can we submit this with the packet?
You have to have the interrogatories completed. If he wants to have a PA or a nurse practitioner fill out the form because they don't have time, and then he can sign off on them, then that would work, as long as he signs them, or she.
If an individual says they do not want a guardian, but family member wants to be guardian, how do you proceed? Does it depend on how independent they are or can be?
I think the team would need to come together, as well as getting the physician's opinion, depending on what everybody feels is in the best interest for the consumer. But the consumer also has right to voice their own opinion as far as what they would like in their life.
You have to have a medical professional say that this person is in need of a guardian. You can't just have a family member say, I want to be guardian, without having a medical basis.
If someone is in DMH placement, like an ISL, their guardian passed away, so I am doing a successor guardianship packet, but no one in the family knows their previous placements. Is there somewhere to get that information?
I'm not exactly sure the answer to that. I don't know if that's something that,
I mean, if it's not in the file, in the consumer's file, I'm not exactly sure either. But a lot of times, from what I know, is that it is listed, stated somewhere in the file, as far as their natural placement or previous placements.
What happens when the SC does not agree that guardianship is needed?
well, I think that's a conversation that you have with the team for the client.
Does criminal background information need to cover assaults or criminal behavior that charges were not brought against the client for?
I believe any arrests anything that criminal charge, or if they were arrested, it needs to be stated. And then I think that there's a place to explain what occurred and why they're not being charged, or that can just be added in for further explanation.
I have one. My packet was sent to the Sykeston Regional Office back in the summer and was on the old form, 2018. The court date is rescheduled for March 1st. Will I need to revise the packet and send back through SRO before the court date?
Yes. With the new packet, the April of 2021. To my knowledge, it won't be accepted unless it's that packet. Unless, Stacy, have you heard differently?
Yeah, it needs to be, because that's quite a ways back. It would need to be put in the new packet.
With the affidavit of no change, if that's how the physician continues to fill in the SC.
Right.
Does the process take?
I'm sorry, you cut out. Was that how long does the process take?
Yes, I'm sorry. How long does the process take?
That varies. Um, once the packet is completed properly and submitted to general counsel, there's not like a set amount of time that it takes because it has a lot of factors in that. Like, I mean, COVID messed things up for a while as far as courts and stuff are concerned. So, but typically, and I say typically, once it's submitted and accepted, um, I'd say a month, 2 months, somewhere in there.
Does the guardianship packet process need to be followed if the family is going through a private attorney or just if we are asking for the Office of General Counsel to review?
No, it does not need to be done if the family is using a private attorney.
Where are SCs getting forms notarized? Are we responsible for finding our notary?
Yes, you are
Yes.
responsible for a notary. And a lot of support coordinators, employers have notaries around. I don't know if you could check to see if anybody in your place of employment has a notary, but sometimes you do.
Right in their office or why?
You know, I think it's just important to note that the division isn't providing a notary service. So it does fall on the responsibility of the support coordinator or the team to get it notarized.
Just FYI, I'm going to just throw this out there, Matt. When I was doing them, we didn't have one in the office at the SLRO in St. Charles. I went to my bank and used the notary at the bank, and they didn't charge me.
Yes, that's a great idea.
I have a new consumer who needs a guardianship packet, and we have little to no information on his background. No one knows his biological parents, and his foster parents have passed away. Is it suitable to just state that on the form?
That might be in question for general counsel. I've never had to contend with something like that.
I think that the team should make every effort to find out everything that they can and make note of that. And then we can give that information to general counsel if the packet is submitted.
You have to write in the information regarding the person's ABLE account.
I haven't had to do that yet.
I would think just to err on the side of caution, note that they have an ABLE account and what's in it.
Do you have any resources to search for relatives?
Online research, Person Finder, Google, that's what I've had people use. I don't know anything. Any other form or whatnot? Stacy, do you know?
I've gotten a lot of addresses from CaseNet.
Mhm.
Other than that, that's just the file and using any previous addresses. If you have an address that you know isn't current, but it's the last one you have, then just send a letter to it and say that I sent the letter.
The certified letter maybe. In a case night, you can also find sometimes dates of birth. They'll give you a little bit more information as well.
If the individual was removed from parents, etc., due to abuse, but is now an adult and would still be concerned, would they still need to be notified?
I'm not 100% sure on the answer to that, but I would think it would have to do with whether or not the parental rights were terminated through that process or not.
Can the limited guardian be a state-appointed guardian? I ask because the individual who I am thinking of does not have any family or friends to help or support.
Well, then that would most likely be a public administrator.
Someone moves from another state and the person has guardianship from the other state. How does this move over to Missouri? Who is responsible to do this? Do we recognize guardianship from another state? What is the SC's role or responsibility at this point?
I would get clarification from general counsel on that question.
So sometimes what we have, what we've heard is I would reach out to your probate court, encourage the family to reach out to their probate court to see if the probate court would allow them to just file or submit their guardianship or order of guardianship. Basically, I would always just encourage someone to start with the probate court and let the probate court advise them on what they need to do.
How do we seek clarification on something from general counsel? Do we use the centralized state guardianship email?
Take that one.
No, Stacy, go right ahead. So here's the situation. General counsel is unable to provide legal advice because they do not represent the individual and they are not representing the TCM entity. They represent the department and the division. So it's kind of a strange question. You can submit a question. We can reach out to general counsel and general counsel may respond and say that they're not able to provide a response or advice. And I want to be very cautious in how I respond, especially because, we respect general counsel and I respect Denise Thomas and don't want to advise you incorrectly or say something wrong. But so typically the questions that you're going to ask, should relate to the guardianship packet itself. And I know that that's kind of a convoluted, answer, but general counsel, does not represent anyone but the Department of Mental Health. They are providing a service to assist in filing the guardianship order. And I hope I'm saying this correctly. And if I'm not, and general counsel's on, I welcome them to correct me. But they're filing the petition on behalf of the division. They are not filing the petition on behalf of the individual, the TCM entity, or even on behalf of the proposed guardian. So, the amount of response that we can typically get from general counsel may be very, very limited. So that's a pretty convoluted answer to a more specific question.
When a guardian passes away, what is the SC's role at that point? Do we hotline this? Do we ask for a successor guardianship? or do we contact the court and ask them for a hearing?
Typically, it would be the successor guardianship packet.
The affidavit of no change document on the DMH website. How do we access it?
You can ask for one through DD guardianship at dmh.mo.gov. Otherwise, it is on the intranet on General Counsel's site. They do have a specific page for guardianship. That's where the packets are. And the affidavit of no change is on there too.
We have someone that says, I might have missed this, but what if the family only wants a partial guardianship? And how do they release guardianship later should the consumer not need it any longer?
It would still go through the packet process for limited guardianship, and just be specific about what areas they're requesting guardianship.
Right, whether it's financial
Or conservator.
correct.
What resources do you have for legal aid?
They just need to look into it in their county or their region. We cannot give out legal advice.
If they're wanting just general information on the legal aid offices, you can Google it. I have information on the different offices throughout the state. Or whatever region you live in, you have to contact that specific legal aid.
Who is responsible for paying all legal fees?
If it is going through DMH, which is the option of last resort, then DMH absorbs the cost. Matt, you have anything different?
Basically, and that's the reason we ask all of the prying financial questions and ask guardians, have proposed guardians, have you gone to legal aid? Have you gone to Catholic Charities? Have you sought your own legal counsel? What's your income? What are your expenditures? That's why we're asking all those questions, so that general counsel has a good idea that this is a financial hardship. Okay. So that's the long answer to a short question. That's why we ask you to provide that depth of information, to determine that to allow general counsel to make the determination that for them to file the petition on the behalf, because it's a financial hardship.
They're in placement with DMH in another state. Do we include that information or just the first placement within Missouri?
Are they currently, I guess that question doesn't make sense. Did the state of Missouri, did the Department of Mental Health, are they agreeing to pay for services in another state? I mean, if the individual is not considered domiciled in the state of Missouri, and so the question then comes down, the individual has to be considered domiciled in the state of Missouri, which means that they are a resident of the state. If they're receiving that kind of question, probably is something that we should talk about in a little more depth, maybe not here. So whoever proposed that question, if you want to email that to the guardianship email box, it's there on the screen there, so that we kind of better know how to answer that question. And we'll put it together in frequently asked questions in a way that kind of would answer it in more general terms.
Client's guardian passed away several years ago, and the courts have never appointed a new guardian. Is the successor packet still the correct one to complete?
If they had a guardian prior to, and there has not been any legal changes to that since the passing of the guardian, then the successor guardianship packet can be completed.
Okay, I'm just, I'm going through some more chats. Victoria says, I thought public administrators only did full guardianships or conservatorships. Is that not true?
That I don't know 100% the answer to. Darcy or Matt may have something.
So typically, rule of thumb is that if we're going to request that general counsel file the petition, then we're typically, especially with the public administrator, we're typically identifying that the individual is needing full guardianship. Again, I don't want to speak for certain. Maybe if the individual asks that question with some more specificity, we might be able to provide some answers. So
Yeah, I
Can we
agree.
do, can we do packet process for successor guardianship?
There's a successor packet specific to that situation. There's a full guardianship packet that's done for the initial guardianship, and then if they've already had a guardian and they need another one, then the successor packet it's very similar, but it doesn't have quite as many pages as the initial packet, and that's because in the original guardianship that this person would have had, they've already gone to court and they already have the legal paperwork saying that they are incapacitated and that they need a guardian. So instead of physicians interrogatories, you just need the original letters of guardianship and incapacitation.
Right, it's not as extensive as the initial guardianship packet.
Please clarify again where to find the updated guardianship packet. The only one I can find online is the packet from September 2018.
You can request a packet from DD Guardianship at dmh.mo.gov.
and this is a great place to just chime in there. Obviously, some teams are going to submit a guardianship packet to us, and they're not going to kind of begin the process with us. Okay, they're going to go out and they're going to get the packet and they're going to fill it out and they're going to submit it to us. And okay, so but realize that once that's submitted and you've gotten it all signed and you've gotten it all notarized, your time frame has started for the validity of that packet. And we're going to review it, and we're going to, if there are issues, we're going to send it back. And we don't get to pause those time frames of the 6 months. So the encouragement really is to begin the process with us, to reach out through the email, so that we can give you the information from the beginning to support the team, to provide that technical assistance in getting that packet completed. There are questions that we're going to ask that the team's going to have to respond to in that packet, especially concerning all other options being exhausted. Financial information regarding, the proposed guardian, those type of things. So we really want to encourage you. It's going to take time. It's not always a fast process. Obviously, there are crisis situations that we can work through and support, but it's not a super fast process. And if we can mitigate the back and forths as much as possible, before official signatures are received, best case scenario is you'd complete the packet, you'd submit it to us without signatures of the doctor and notaries, so that we can review it and give you feedback and send it back. and then say, hey, once you've got this fixed, let's look at it. Now go get your signatures, go get your get it notarized, and then submit it to us, then we're really looking good on time frame. So that's a long answer to a short question, but that's best case scenario, so that you are not having to look at doing that, affidavit of no change. Doesn't mean that we won't have to, but if we can do it if we can lessen the chance of it, we want to do that.
This is the last question I see that we haven't covered. Can you clarify that if the person was adopted, we do not reach out to non-parental relatives?
Well, we said what we thought to be the case, but I don't know, that's bordering.
We'll just have to ask that of general counsel and ask them to advise us in what to do. If the individual's parental rights were terminated, then it's not likely that the court is even going to be willing. That general counsel will most likely be willing to submit the petition if their rights have been terminated. But we can ask for clarification with general counsel.
More that came in. Can you provide the website where these documents are located? And since I have a March 1st court date, do I send the new packet back to the Sikeston Regional Office or to the DD Guardianship email?
If you've already started the process with someone, I think that you would just continue the process with whoever you're working with.
Right, don't send it straight to the email, send it to the information specialist.
Well, and unless you started with a guardianship coordinator that wasn't with the information specialist. So if they were working with somebody at Sikeston, and if you want to reach out to us through the email, let's see how we can facilitate that best. That's kind of a very specific question. So, reach out to us through the guardianship email box about that question specifically, and we'll see what we need to do to answer that question.
Okay, I think that's about it. Do have someone asking for the website where to find these documents again.
I was going to say that this is going to be available, this PowerPoint, correct?
Yes.
Okay, well, the website is on one of the first few slides of this PowerPoint.
Right, you can look on the intranet under the general counsel's page, and it'll say guardianship information.
If you don't have access to the intranet, then you will need to request it through the email.
Email, correct.
That's on the DMH. That's like the DMH intranet. So there will be certain folks that don't have access to that page. So that's really why we want to encourage you to begin the process with us by reaching out to get the forms. Okay.
How do we bill for this? Our contract states that we should not bill for direct case management. This is direct case management. How should we bill for this? I think that is not a question for you guys. But.
Well, we did. So this question did come up. I brought it up during our first webinar. We've done extensive research. It is billable. It is billable through case management, through the targeted case management codes. It is considered a Medicaid billable service. I can't advise you on what code to use, but I can tell you in no uncertainty that it is a Medicaid billable service. I don't know if you would use planning supports. I'm not sure, but it is billable.
That's the last question.
Very good. Well, we appreciate everyone's participation. Like I said, we'll get all of the questions that we've answered today, we'll create a frequently asked questions response form and put it out in the next few weeks.
All right. Thank you, everybody.
Thank you.